EJIL has always prided itself as being innovative, and some years ago, as all of you listening or watching this will know, we started EJIL Talk, which is our blog, and of which we are very proud. It creates a conversation and an EJIL community, which the journal alone would not sustain. And what we are doing now is to create something we are calling EJIL Live, which will accompany each new issue of the journal and will include, among other things, an interview featuring one of the authors and one of the articles in a recent issue of EJIL. Yes. I have here with me Dr. Maria Aristodemou, who will have published in the first issue of 2014 an article called A Constant Craving for Fresh Brains and a Taste for Decaffeinated Neighbours. Now, I am going to assume that some of you listening or watching this will have read the articles, will have read this article, and might have a lot of questions to pose to the author, and I'm going to try and be your proxy. And for those of you who have not read it, maybe this will be a trailer or an appetizer to incite you to read it. Obviously, the fact that we published it makes us believe that this is very well worth reading and thinking about, different as it is from the mainstream. Maybe I can give those who haven't read it a taste of it. The way the article is structured is that Maria, if I may, and you can call me Joseph, Maria has taken a classical case from the annals of psychoanalysis, a case which is described by the psychoanalyst Chris, and which was later commented on and critiqued and become foundational by Lacan, and a way to understand and enter into Lacanian psychoanalytical thinking. And she presents the case, and then she uses it not just as a metaphor, but actually as an explanatory apparatus to some features of public international law. So we will talk a little bit about the substance of the case in a few minutes, but on a more personal level, maybe you can tell us a little bit about your background. How did you get to write this kind of article? We get a lot of submissions at EJIL, but this is one that, even for us, is a little bit out of the ordinary.
I guess there has always been a sort of identification between me and my subject, in the sense that if I portray public international law as a hysterical subject, in the sense that a hysteric in the Lacanian dogma is someone who doesn't know what their desire is, but looks for other people to find out what their desire should be. So a hysteric's desire is always the desire of someone else. And I guess my own desire, I see myself as a hysterical subject in the sense that I look, like all of us, to other people, other disciplines, other institutions, to find out what we should want, how we should live, how we should go about our business. But I find international law suited me, and I identified with it because I feel it has the same problem. Traditionally, it's never been sure of its place. It's always looking elsewhere to find a source for its legitimacy, its raison d'être. So I think out of all the subjects in legal discourse, international law best exemplifies the nature of hysterical desire. Its identity, such as it is, it's more obviously an identity that is based on identifications with other things, other people, other disciplines. So I'm saying in the article and elsewhere that is the nature of identity anyway. All our identity is always borrowed from bits of other people. But in international law, it's even more blatant, much more obvious, because it cannot hide the fact that is a collection of bits of other discourses, and particularly theology, politics, religion, as well as mainstream law. So it best exemplifies my argument that identity is always a series of identifications, often false identifications. There's never a sort of solid identity. In fact, we only have a solid identity when we die. The death mask, in some respects, is the final print. That's when we can say it's a closed identity.
Just before we continue on the substance, and your background is as a psychoanalyst, as a psychologist, what's the background you bring to this?
Okay. My own background, I mean, I'm a lawyer. I studied law. I studied public international law at Cambridge. And I guess I'm from Cyprus, yes? Cyprus as a nation, if you like, as a country, is itself riddled by problems of identification. It's always had a history of being colonized and occupied, and that history continues and is unresolved. So in the same way that I suggested, I was finding some kind of identification in the hysterical nature of international law. The fact that I am Cypriot, and Cyprus has always been uncertain of its identity. Is it part of Greece? Is it its own nation? Has made me to look for international law for some kind of answers, or for some kind of... so therefore I studied international law. I started teaching law very early on. I started teaching at Bristol University, and now I'm at Birkbeck. But I never found that legal discourse was satisfying enough for addressing problems that legal discourse itself threw up. So I started looking at literature as a way of opening up the categories of truths and that we can address in order to find out what the law is. I started looking at literature in particular. So my first major work, to date my only major work, was on law and literature. And the argument there was that law is a kind of elaborate, majestic, very impressive palace, but it's also a kind of labyrinth where those inside it get lost, those outside it find it very forbidding to enter. Yes, and in particular in my book on law and literature, the main thread was that if there's one group of subjects that find it hard to enter the legal labyrinth or have been deliberately excluded, have been women. So my address of literature was a way of letting women into the legal labyrinth. The idea was that literature, a wedding between law and literature, was more likely to open up the doors of this legal labyrinth to women. And the idea, it was a metaphor inspired from a short story by Jorge Luis Borges, where he portrays the labyrinth in a way that makes you feel sorry for the Minotaur. The Minotaur inside is not the monster to be feared, but to be pitied. And my argument in the book, I imagine the legal labyrinth, the legal Minotaur, as being actually quite lonely. It's been forbidding all these other subjects, especially women, from entering, but it's consigned itself to a life of boredom, loneliness. So in some respects, the entry of literature and of women into the legal labyrinth is not just good for women, but it's also good for the lawyer who has lost himself inside the labyrinth. I mean, that was the beautiful metaphor in Borges, where the Minotaur is lost in his own labyrinth. So that was the background where I was allowing literature in. That was a long time ago. Then I realized also, shortly afterwards, I mean, that was when I was young. And the book, at least that book, ended in a very optimistic celebration of this so-called sort of union between law and literature.
Tell our listeners or our viewers the title of the book.
Oh, it was called Law and Literature, Journeys from Here to Eternity. So
And it was published
by Oxford University Press.
And when?
In 2000.
In 2000.
A long time ago. So it took me time to assimilate the message I had arrived at, but also its consequences. And several years older than I am now, I realized that that marriage was not necessarily, the honeymoon didn't last. I mean, it lasted enough, but like all marriages, it started showing problems. And
that's an interesting statement about marriages.
Well,
I'm just teasing, go ahead.
Yes, well, okay, the problem I perceived, and I perceive in marriages for what it's worth, in all unions, is that if law in that particular project fell in love with literature fell in love with law, the problem in this kind of unions, and I think it applies to human subjects, not just disciplines, is that we end up idealizing the other person or the other discipline to such an extent that we give up or we stop interrogating our own limitations. The whole point, I think in human subjects as well as in looking for other disciplines, is that when I fall in love with someone, or law fell in love with literature, as in my book, the idea was that, okay, law excludes women, law doesn't take in emotions, law doesn't take in the other, law marginalizes non-white, Western, middle-class men, or whatever, yes? Now, I can look at literature, and all those excluded voices can suddenly be represented. If I allow literature into law, all those excluded voices can be represented. Now, the problem with that kind of...
although the same critique has been made of literature.
Yes,
that it excludes exactly the same voices, etc.
Precisely, exactly. So that was one of the problems. That was the main problem, that you idealize literature to the extent that you forget that literature is itself ideological. It has its own exclusions, its own problems. But also, it does conveniently enable the law and the lawyers to continue to ignore what is wrong with the law and with the legal structure. In other words, we put the hard work of including those voices onto the shoulders of literature, which enables me to carry on being the same old legalistic lawyer as I always were. Do you see? So, and this happens, I think, as you pointed out, in marriages, and it's where you expect the other person to complete you, to make up for what is lacking in you. And the result is that you end up ignoring your own limitations.
So that's
doing nothing about them.
That's in some ways one of the very central points in your article. Because you describe the classical KISS case of the author who is afraid that what he's writing is plagiarism and therefore he can never write. And you come to the same conclusion. So just in 2 or 3 minutes, describe the case that KISS presents, and then we'll talk about Lacan's critique.
Yes. Okay, it's a beautiful case that I think any academic is always taken in with. And it took me a long time to work out what was going on and why Lacan was so obsessed with it, because Lacan kept going back again and again to the case and gave different cutting critiques of it. But okay, the case takes place in 1950s New York, where many of Freud's followers, including Ernst Kriess, had found refuge after the Second World War, or during the Second World War. And according to Lacan, and not just Lacan actually, this is well known among psychoanalysts generally, they took with them to New York and to the United States generally a version of Freud that Freud would not have been happy with. I mean, if you remember when Freud arrived in New York with Jung, supposedly this apocryphal anecdote supposedly goes that Freud turned to Jung and said to him, all these Americans are welcoming us because they don't realize that we are bringing them the plague. And sure enough, the history of what happened to Freudian psychoanalysis in the United States confirms Freud's prediction that they did not want to take in the plague. What they ended up doing is take the sweet bits of Freud, or they sweetened it, they domesticated it. So the radical message and the subversive message ushered in by psychoanalysis, Freudian psychoanalysis, was completely ignored.
But let's maybe go back to describe to our viewers and listeners very briefly the actual case itself before we get into the family feuds among the psychoanalysts.
I know, it's very hard to get away from them because they are, the Oedipal struggle is everywhere. Okay, so Ernst Kris was an academic. No, not Ernst Kris, the patient whose name we never know, was an academic who had great difficulty in publishing his work. And as we know, if you're an academic, obviously you want to publish your work, otherwise it's not good for your career. Now, the reason why he was reluctant to publish his work was not just that he was plagued by good, normal insecurities, that his work was not ready, it wasn't good enough, he needed to work further, which is fair enough, we should all be at that stage. But in his case, it was an even more demanding inhibition, whereby he assumed that everything he ever wrote was already a plagiarism of existing work by other people. So every time he was on the verge of publishing something, he would decide that it had already been written, he was only plagiarizing something that had already been written, so he would stop himself from publishing. And he enters analysis with Ernst Kris in part to overcome this inhibition. Now, Ernst Kris listens to him, session after session, and finds out during the course of these sessions that this particular patient had a grandfather who was already a very famous scientist and had published many things in the past. Anyway, he listens to the session, he finds out more about the patient, until one day the patient arrives and announces that he has actually finished something and that he is ready to publish it. So Kris is thrilled. Finally, he thinks some progress is being made. Sure enough, however, next session, the patient returns only to announce to Kris, and note he announces to his analyst Kris in a very excited way, which is very suspicious for Kris. He's announcing that, sorry, that paper I told you about last week that I finished and I was about to publish, absolute rubbish. It's a plagiarism of another work by someone else. I must have read it because it's already in the library, and I have, so really, all my enthusiasm is back to square one. I haven't published anything new. So Kris is surprised that the patient is suddenly pleased in some respects, that he has proved himself to be a plagiarist after all. So Kris does something that later Lacan criticizes heavily, where Kris, the analyst,
he actually checks whether it was published, and he discovers that it's a figment of the patient's imagination.
Exactly.
There was no published, it wasn't plagiarism.
Exactly.
And then Kris works towards a conclusion.
Yes, he announces to the patient that I've checked the two papers, you haven't plagiarized the earlier paper, so go away, you are not a plagiarist, you can publish it. So the patient goes away, and as he's about to leave the session where it's been announced to him that he's not a plagiarist, he turns to his analyst, Kris, and says to him, you know, every time I leave the sessions, I go to such and such a street, and it's a street where is well known in New York for having a line of beautiful bijou restaurants. And the patient says, I look through the menus of those restaurants until I find my preferred dish. And my preferred dish is fresh brains. So basically, the patient who thinks he's a plagiarist, on being told that he is not a plagiarist, that he does have fresh brains of his own, when he leaves the session, goes in search of fresh brains in the flesh. He actually wants to eat them, literally. So in psychoanalysis, this would be called an acting out. He's been told he's not a plagiarist, so he says, I'm still going to go and eat fresh brains. I still need fresh brains. So the treatment has not worked. He's still after fresh brains, this time in the flesh.
And then there's a kind of sequel with the grandfather.
Okay, yes. So this is the Chris's interpretation, which is an interpretation that Lacan is not unhappy about. He confirms that this was the real problem with this particular patient. And this was the fact that what the patient was doing all this time was preventing himself from publishing because publishing something would have meant that he was coming into conflict with his famous grandfather, in other words, etymologically, the father who is great. So he would have been competing in terms of quality with his great father. So in short, what the patient was doing was protecting himself from engaging in the Oedipal struggle. He was protecting himself from entering in the good old Oedipal struggle by using the defense of plagiarism as a defense against coming into conflict. So plagiarism suited him very well. He'd never publish anything, which means he would never come into conflict with his great father, his grandfather. So this is
now,
a good
and then the next move in our analysis is to generalize the situation, right? And say this is not just a particularistic instant of this patient, but it says something about the human condition itself.
Exactly.
And the human condition itself, it's a proxy for what?
The human, well, for Freud, obviously, the Oedipal struggle is endemic. It's part of our, it's what we all undergo in order to become subjects. We all have to go through some kind of Oedipal process, more or less successfully, mostly unsuccessfully, but the failure is what the way we fail, and we all fail one way or the other, but that failure is what constitutes us as subjects. So there's no getting away from the loss inflicted from us, from the Oedipal struggle. At some point, we have to go through the Oedipal struggle and lose something. For Lacan, what we lose is something that is inflicted by language. For Freud, it was more metaphorical. It was the so-called castration inflicted by a forbidding father. But what's important is a lot of people who are not familiar with psychoanalysis are not, they sort of have a problem the minute you mention the word castration. What's important to recognize is that castration doesn't mean literal cutting off of an anatomical piece of us. It's actually a metaphor for loss. We lose something. We have to get used to it. We have to lose something in order to become subjects. And in fact, it's that loss that defines us as subjects. So we shouldn't be expecting, as we're going back to our earlier discussion, that at some point we'll recover this loss and we look to other people when we get married or fall in love, or to other disciplines when we indulge in interdisciplinary in order to make up for that loss. That loss is endemic. Forget about it. It will always be lost.
And now maybe tell us the essence of the Lacan critique of the KISS interpretation, or the KISS approach even.
For Lacan, The problem with Chris's treatment of the patient is that Chris takes the patient at their word and enters into the patient's imaginary, what Lacan calls the imaginary register, and tries to cure the patient at the level of the patient's ego. In other words, when the patient says, I'm a plagiarist, the analyst takes him at his word and goes and checks whether the work produced by the patient is indeed a work of plagiarism. Now, for Lacan, the last thing the analyst should do is meet the patient at the level of the patient's ego. What Lacan insisted and what he thought was wrong with the way psychoanalysis was received in the States was that they took the be-all and end-all of Freud's technique as being focused on treating the ego. Now, for Lacan, the ego is purely imaginary. It's a misrecognition. From the moment we encounter ourselves in the mirror stage when we are like 12 months old or less or more, what we see ourselves is always a misrecognition. The last thing the analyst should do is enter the patient's imaginary and address their ego, because the ego itself is a misrecognition. And what Lacan pointed out and noticed was happening in ego psychology versions of Freud was that what the analyst ended up doing was to try and rectify the patient's ego, which meant, in effect, that they were trying to make the patient after their own image, after the analyst's own image. I mean, the analyst has their ego as well. The analyst's ego is also imaginary. If I'm an analyst and I'm trying to cure a patient's ego, what I end up doing is make the patient's ego in the image of my ego.
And what would Lacan instead have the analyst do?
Devastate the subject. The Lacanian analyst will be really nasty, will not protect or defend or sympathize or save the patient, but destroy the patient. Destroy the patient's ego in order to create it anew, in order for it to be created anew. I mean, the analyst doesn't do it, but what the patient will do it by themselves if they keep talking. But what the analyst must refrain from doing is what Chris did, where you go and say, there's nothing wrong with your work. That's the last thing an Lacanian analyst would do. It would be, yeah.
So now, those of our listeners or viewers who have not read the article in EJIL are waiting at this point. Tell us how you translate this, how you use this for your analysis of international law.
Okay. Well,
because until this point, they
haven't talked much about international law.
They are looking at me and saying, you're the editor-in-chief, why did you publish this piece? So,
oops. I hope not.
No.
Okay.
So how do we move from the case as a metaphor or an explanation or an insight into international law?
Okay. Well, I see international law as the typical neurotic patient after the image of Ernst Chris's patient, who is hysterically looking around to make up for their deficiencies by imitating, copying, trying to be like other disciplines. And this is, looking at various approaches to international law. I suggest this is because international law, like any subject, like any discipline, is plagued by a lack at its center. Just like we said the human subject is, so is every discipline. Now, the good thing about international law is that the lack is obvious. It's much more obvious than it is for domestic law. But it doesn't mean that the lack can never be filled by looking at other disciplines or other ways of doing things. And I think with international law, even more clearly than for other areas of law, although it's still the case for them, this big other, this great grandfather that we saw in Ernst Kries's patient's case, in international law is this big other of God.
You say is God?
Yes. The aim is to fill the gap that was once upon a time filled by the omniscient divinity, the entity that knew everything, legislated everything, owned the universe, owned the earth, owned every territory, legislated. And with the so-called death of God in modernity, this gap is more blatantly empty than it ever was before. What I'm saying is that the gap was always there. It's not like, this is a beautiful way of putting it by a Portuguese poet called Pessoa, where he says, when God supposedly departed with the advent of modernity, the gap was obvious for all of us to see. And therefore, we had to start filling it in with rules. Kant's categorical imperative is the one that I focus on in this article. But this was the case in every area of law, not just international law. But the thing is, God was always ever a screen for hiding the gap. The gap was always there. So when modern man, or modern man rather than modern woman, as we know, supposedly killed God, the gap became much more obvious, much more, because it was left empty. God did a really good job of filling it.
And then you're saying, so the attempt to fill that gap is, for example, the turn to other disciplines, the law and economics, politics,
Exactly.
all those other disciplines.
Yes.
And you say, just like Chris's treatment of his patient, that's condemned to failure.
Yes.
You can't fill that gap.
Yes.
International law will still go out and look for fresh brains.
Yes.
So you cannot fill that failure. And then take us to the next step.
The next step is to acknowledge the gap for what it is. If we don't fill it up with fresh brains or other disciplines, we leave this gap much more plain for us to see. And what we discover, unfortunately, and that's why, as I said in Lacanian analysis, the patient is devastated, because it's the last thing we want to discover, and that's why most people don't go through it, or disciplines, is that inner core, that gap, is absolutely ugly. It's obscene, it's terrifying.
It is absolutely ugly, you say.
Ugly.
Obscene, terrifying.
Obscene, terrifying, evil. Is something that we don't want to acknowledge exists. And therefore, in this paper, I give you the term exteammate. And it's a term that was coined by Lacan. It's a beautiful neologism, because what it refers to is something that is so incredibly intimate that we have excluded it, not on the outside, where we could just ignore it, but we have hidden it inside, where no one, not even us, would bother to look. So it's exteammate. It's excluded inside, in the interior. And therefore, we spend our whole lives trying to look, trying to find it. Zizek, actually, who I refer to a lot in this paper and is my big influence at the moment, calls it the known unknowns. I don't know if people are familiar with Zizek's corrective to the Secretary of State's epistemological categories when it was during the Iraq War, when he was telling us about the known knowns and the unknown unknowns, and in a White House press conference about the weapons of mass destruction, the supposed weapons of mass destruction in Iraq. Well, what Zizek points out is that in that press conference, what was not mentioned were the known unknowns, things that we know, or our unconscious knows them, but we don't know that we know them, and it takes the shattering impact of a trauma or a long analysis to discover them. Most of the time we avoid them.
Towards the end of your article, so you take us through these moves. We understand now the way you use the case as a metaphor, the attempt of international law to close that gap that at least becomes visible with the so-called death of God is unfulfillable. Mm-hmm. And then there's a kind of mixture between the discipline and the personal.
Yes.
Just let's finish we've kind of walked through the article. So for international law, in a way you just leave it with, it's futile to try and fill the gap in that way. You have to recognize what you call the exteammate, but you do not describe the evil, horrible, terrifying of international law. That's actually left undescribed in the piece. And then it finishes almost with a personal statement.
That's it?
Yes. So
Okay.
you talk about the individual rather than international law, almost about yourself.
Really? I thought I gave two examples of the exteammate, which international law does have and should have, and if it doesn't, should have something to say about and adjudicate about. But in fact, my argument is that international law, like all laws, come against a brick wall because they are faced with the exteammate, and that is what I think we should focus on. And I give two examples, and I give. I said that the exteammate, because it's so ugly, we very, very loath to acknowledge it, but we are only too ready to acknowledge it and point it at when we see it in another person or another discipline. And I give two examples. The first example, where we ascribe it to the other person, to the neighbor, as Lacan would say, is the example of the niqab wearing the hijab in public. And I give the example of French legislation recently, there's talk in the United Kingdom of the same kind of legislation being brought in, where it bans the wearing of the niqab in public. Yes, and there's been now we know from international as well as domestic law and human rights discourse generally that we're supposed to tolerate the other, everyone's religious beliefs, everyone's dress, opinions. And France is supposed to have been at the forefront of this sort of so-called celebration of tolerance, multiculturalism since the Second World War. Nevertheless, when it comes to something that is so incredibly unfamiliar, what Lacan would call the exteammate, even French so-called tolerant human rights discourse comes to an abrupt end. So I use that as an example of the exteammate.
I'm not sure everybody would find that persuasive. Mm-hmm. Because the reader will say, yes, that's what France did.
Yes.
That's not every country did that.
Yes.
There's a difference in the practice. Some countries accept, some countries don't. But that example doesn't say anything about the discipline of international law. It's just a an example of a society which might correspond to the Lacanian analysis, etc., of not seeing the evil in themselves and then projecting it onto the other and all that. But by using that example, you have made no statement about the discipline of international law. It's not even part of the example.
I guess the argument will carry on, though. I've left it for international lawyers to pick it up, because what I am seeing, not just in the example in France, but in the UK and in Europe generally, and in other countries, is that the same lack of tolerance of the neighbor who doesn't look like us is not just in France. I mean, that's not an isolated example. Okay, in France, it's obvious, and that's why, but in the United Kingdom last summer, we had the Home Office saw no problem having vans, these big vans driving around the streets of London, and the advert said, if you are an immigrant, go home. Now, what I'm saying is that this kind of intolerance is found in countries everywhere. The illegal immigrant, the refugee, the homo sacer, as Agamben would call them. Now, what I'm saying is international law is not dealing with that at the moment. It's not dealing it at that level where it's not absorbing or acknowledging this problem that domestic applications of international law are not following. No? You think international law is... No. What is it doing about the fact that its refugee laws or its human rights laws are in individual countries being trampled upon?
I think our listeners or our viewers might still have two objections. Factually, they might say, it depends. When, for example, the Swiss, again, banned the minarets, I think everybody in the international interpretative community, legal community, would say that's in violation of international law. It clearly is a violation on grounds of discrimination, etc., etc. And for these examples, there's a rich legal discourse where international law actually does condemn these things. But that's at a more profound level. One might argue the dispute is not that our societies can or are be xenophobic, that we have this tendency to project our own weaknesses on the others, that we are fear of the others, but that it's not a statement about the discipline of international law. And you see, that might be one of the radical critiques of the article, is that the metaphor doesn't work. That when we come to think about it, and in a few minutes I'll ask you some more questions about it, you're saying something very important about society. And we get a Lacanian insight about how to understand certain bad, negative, evil aspects of our social behavior. But it's not readily apparent that you're making any statement about public international law. And that's independent of the fact whether international law puts it on its radar or not. And I think it does. I think a lot of these practices are very much on the radar of human rights law and international law, and very often condemn it and say that's violative, etc. But the point is, it's independent of that, because you're not describing something about the discipline of international law at all by just describing the social behavior. So that somehow, and that's, I would say, might be the more radical critique of the piece, the expectation that we can learn from the Chris-Lacan debate about the discipline of international law at the end doesn't work out, because the exteammate that you are describing is not an exteammate of international law at all. It's an exteammate of our social behavior as society.
Well...
Don't be kind.
No, I don't think the response from a Lacanian would be that international lawyers, even at their most critical, even at their most radical, are not radical enough because, as I explained at the beginning of this article, they are very good at dwelling in two out of three registers, in the sense that they know the law. They can understand the documents and treaties and resolutions. And they also, secondly, as you just pointed out, are very good at analyzing, criticizing, critiquing those manifestations of the law in the practice of states from the point of view of ideology, from the point of view of politics, from the point of view of everyday results that we see. Now, so you can have, all sorts of religions of critical international lawyers. What seems to be missing is the third dimension, which Lacan calls the third dimension of the real, which I don't have any answers apart from the examples and my exemplification of it through the Exteammate and the examples I gave. I don't have how to approach the real, but the point is because if there is one thing about the real, it's unrepresentable. It's beyond legislation. But what international lawyers, including those who critique the ideology of international law and its politics and its manifestation in everyday practice, always, you could say, like with Chris's patient, they're still dwelling on the realm of the imaginary, on the realm of ideology, on the realm of the ego. And even if I'm a very politically active international lawyer, even if I'm forever fighting for all these causes, what I need to also be doing is analyzing my own engagement, my own, because if I think I'm being critical, if I think I'm being tolerant or open, maybe what I'm doing is solidifying my ego. That
Correct.
I'm saying
And we can,
I'm better than other discourses of law because I'm more just, I'm more about reconciliation, I'm more pragmatic, I'm more...
So let me
Yes.
maybe just clarify this. So that I find persuasive that when we look at the individual international lawyer, the activist, the radical, etc., one can make a strong case that even though he or she might believe they're doing the right thing, etc., they in some way masking their own internal exteammate. And that's where I thought what I hinted that at the end of the article, you again personalize it. And maybe we can leave it at that. I'm not sure that you make, and that's something to think about and maybe further develop, the relationship between that position of the individual international lawyer and the actual discipline of international law. Mm-hmm. That you're making a statement about the discipline. There's always this kind of tension between this is the discipline of international law and these are the actions of international lawyers utilizing the discipline. And there's a little bit of fuzziness there in the piece. And if I can maybe leave that because it's not necessarily to resolve it here. One might also question the beginning because the description of the malaise of international law, I'm sure some of our readers would immediately sympathize with this. You know, the international law that is insecure, that is looking for validation through other disciplines, etc. But others of our readers and authors will say, yeah, we're familiar with that approach, but we have a much more modest, self-limiting, positivist idea of international law. We don't think it's inadequate. We're not saying that it's adequate. We're just saying it is what it is and it can't be more than that. And I think, so some people will say, or might say, I don't recognize international law as the patient. Because when we started our conversation, we said international law is the patient who in some way recognizes the inadequacy. You gave the explanation, the death of God, that kind of certainty, which at least exposed the gap. But I think there might be others who, in a at least self-deceptive way, will say, no, international law is the limited enterprise it is. It can do what it can do. It can't do what it cannot do. It's not a substitute for politics. It's not a substitute for morality. We're not looking for international law to fill in all those gaps that result from the death of God. And therefore, they might critique the piece by saying, it's not that we don't recognize at the end of the day the exteammate of the discipline. We don't even recognize international law as the parallel patient to Chris's patient.
On the fuzziness between individual international lawyers and the discipline, just very, very briefly, I'd say, you know, the identity of the discipline is, I mean, the discipline has no essence in itself except for the identity brought to it by individual practitioners, writers. So in some respects, the fuzziness has to be solidified through the conglomeration of all these fuzzy individuals, creating an identity which is but an identification of all of them together. On the second point about some international lawyers that might not recognize themselves there, well, in that case, the analysis will take longer. In that sense, for the critical international lawyers, the task for the analyst would be, I mean, the way you described it, and I do remember some international lawyers like that, both in Bristol and Cambridge, where they don't recognize any problem with the discipline.
Oh, they're not that they don't recognize any problem. There are lots of problems in the discipline, but not of the type that you premise,
yes,
which is international law has the aspiration
yes,
to this totalistic,
okay,
that it's both morality, that
yes,
it fills
yes,
the gap
yes,
of the death of God.
Okay.
They say if you set it up like that,
Yes.
then the analysis works.
Yes, yes, yes.
But why should we expect law in general or even international law? Why should we expect international law, even law in general, to fill those kind of gaps?
Sure.
We don't look to law or to international law to give us all the answers to our moral dilemmas, to the human condition, etc.
Yeah.
It's only because you set it up as searching for that, that you create the problem, the false solution, and then the correct Lacanian solution.
Obviously.
And this is not about denigrating. I remember some lawyers in Cambridge or Bristol who were like that.
Okay, no, this is a really good point, and I hadn't thought of it. And actually, there should have been another section in that article in that case, because we did start this conversation by pointing out that I identified with international law as the hysteric, and therefore identified with the early description of it as looking for something to fill the empty place and looking to other people to complete care. Now, the other kind of patient that analysts see on a regular basis, who I completely ignored in this article, and you are absolutely right to point out, I should have looked at, but I didn't because I don't identify with them, is the obsessive. The bottom line is both obsessive and hysterics are both neurotic. They both have a gap to fill. The hysteric, like me, like international law, or the international law I presented here, which is only one side, as you pointed out, looks to other people, other disciplines to complete here. Now, the other patient that I haven't given any room in this article, and you're absolutely right to point it out, is the obsessive, who, rather than looking for other people to complete here, busies themselves to such an extent to efface the gap. So there's no room for the gap ever to be visible. And you could say
that is
accumulating more and more rules, institutions, more and more decisions, more and more resolutions will make me forget that there's something missing. And that is the obsessive.
Even there, still if I want to probe a little bit, we would have the same problem or challenge in the transfer from the psychoanalytical patient to the international law, because if I relate to the answer you gave us a few minutes ago that we can't separate the international lawyer, the human subject, from the discipline and go with that, it's not that the second type of international lawyer does not recognize gaps, etc., that is not working under the weight of modernity, the so-called death of God, etc. It's just they're not thinking that international law is there to give the answers to that. So they might be hysterical in the sense that you described the first patient, if I'm focusing on the human subject, but where one might probe or push you a little bit back is to say you somehow believe that that gap they look to fulfill through the discipline of international law, through the professional dimension of their life, etc. And they would say, no, this gap is huge, it's burdensome, it's terrifying, but to imagine that one would expect international law to give all these answers, to be the one and all answer of morality, etc., that's where the challenge might be to the transfer from the psychoanalytical case to the patient we are now calling international law / international lawyers. So it's the answer through the obsessive might not be a real answer, because it might still be a hysterical patient, except the grand-père is not international law. We look for it elsewhere, and international law is... So you set it up in that way. I've diminished the importance of international law.
Yes. Well...
Whereas you...
Yeah. Well, no. I think that's absolutely right, and it's actually... what I suggest at the end of the book would be the hallmark of an ethical subject. Maybe when I was immersed in international law, I hadn't reached that hallmark of the ethical subject where I acknowledge the limitations, my own limitations, and of the subjects, and of the disciplines. The gap is there, is unfillable. Maybe, like you say, I was hysterical trying to fill it. Now, I find this is the
Those
kind of a lesson. I mean, but...
No, I'm teasing, please.
No, but you see, I think, yeah, coming to terms with our own gap, our own Exteammate, is the hallmark of an ethical subject. I don't think many of us get there until very late. I mean, it's almost, Lacan calls it as coming to terms with your own mortality. And it's something that most of us, most of our life, refuse to accept. In the unconscious life, Freud says, we all think we're immortal. We might, we know we're going to die, but unconsciously we think we're immortal. And so really consciously coming to terms with our own mortality is something that we strive to and only comes very late. Now, in that case, the patient you describe would be the ideal ethical subject that has come to terms with its own limitations and doesn't look for it to be filled
but
up.
Maybe I'm not sure we're on the same page, because that patient might still be hysterical, that patient, except they wouldn't be looking to international law, etc. That's where. But I want to ask you, because I think there's one other area where I would be interested in your reaction. So, the paper is marvelous in its critical nuance, in its introspection, in its self-examination. And I don't just say this façon de parler. It's really a hallmark of the paper. What seems to be one huge lacuna: Lacan is God. Never questioned, never critiqued. What he says is the truth, is Torah from Sinai. Even the way you write it, if Lacan says it, it's dispositive of the issue. So there might be a gap. One way in which the gap is filled is to find Lacan and...
absolutely. To find Lacan lacking. That would be a step forward. Absolutely. You are absolutely right. To rewind a bit, I mean, yes, the hysterical subject might not be yet an ethical subject. I wanted to put something in her defense, though, and how that might help not just the subject, but the discipline generally. If there is one thing about my way of portraying international law as a hysteric, and myself included, if there's one thing that everyone, analysts generally, but philosophers as well, credit the hysterical subject for, is the fact that they won't rest. They will always, unlike the person, the international lawyer you just described, who says, I don't expect international law to do that, therefore, why are you expecting it? So the hysterical subject is always like, no, I want international law to do that as well, and that, and that, and that, and that. She's always provoking. And that's why for Freud, I mean, obviously they invented, hysterics with better psychoanalysis. Lacan credits them for inciting revolution because always challenging the master. The master cannot come back and say, I'm only international law, I can't do everything. No, the hysteric will say, why not? You should be able to do everything. She's always challenging him for not being masterful enough. And that is good for the discipline, is good for the master. Because the master, Lacan says, my master, Lacan says to the students in 1968 when they tried to disturb one of his lectures, and he turns around to them and says, you're only looking for a new master, But the good thing about hysterical subjects, including the students of 68, was that they were not happy with that master, and they keep challenging him until the master gets better. He'll never be the absolute master, because the absolute master is God. But at least we're stepping, she helps him, she provokes him into more knowledge, more discipline, and that's always a good thing. So, I mean, every good politician, philosopher, revolutionary, it was either a hysteric in him or her, or a hysteric pushing him or her. On the second point, you are absolutely right. I'm not challenging Lacan enough, or Zizek. And that's, for me, when I become the real ethical subject, that would be much better when I start challenging. I have been challenging Zizek, actually. I had an interview with him recently like this, and I did challenge him a bit. So, but Lacan, you're right. I'm not challenging him enough, if you said that. So you're absolutely right.
Maybe we should.
Good point.
I think anybody who's been listening or watching, if they have not read this piece, will be enticed and excited and hysterically rush and read it. And those who have read it, I want to believe that you will agree with me that this was interesting and illuminating, and one can understand the piece in a much more profound way than by simply reading it. I want to thank you very much.
Thank you
all.
very much for your probing questions.